So the first thing you're going to consider, let's all turn to page. Is the air on? Let's all turn to page. Free speech. I love that approach. Religion. 404. As I check on the air. Pardon. Excuse me. Okay. So what's the first thing we're going to consider? The state is trying to pass a law and someone is challenging it. What's the first thing we're going to consider? Thank you. Oh, who said? I'm just so happy that someone said that. I don't know who said it, but I'm just so happy. All right. I'm so happy someone did not say preemption. Okay. Standing. What else? Well, state action, all separate IRACs, right? And then possibly maybe mootness, maybe ripeness, separate headings for both. Okay, you may have third party standing. This is the beginning of every single con law essay. Okay. So your first heading will be, under that, preemption. Why do you think we go right into preemption initially? I'm going to tweak this approach a little bit, okay? So copy this checklist as, the approach is still important, but this really simplifies things. It's going to simplify where you need to go, okay? This approach is too wordy. I gave it to someone to modify and they messed it up. Okay, so why do you think we start with preemption, logically? Why do you think? Acted in that area. We're trying to see if Congress has already preempted the field. Does everyone understand what that means, preempted the field? They have a law already in terms of what someone can do in that area, right? So they've already passed a law within that area, whether it be the environment, whether it be voting, whether it be gay rights. It could be anything. We look to see, has Congress preempted the field? And we're looking for either express or implied preemption. We're looking for either express or implied preemption. If you go to page, so clumsy. If you go to page, give me 1 second. There we go. 380, just keep a spot on the approach. The Constitution and the laws and treaties made pursuant to it are the supreme law of the land via the Supremacy Clause. There are 3 kinds of preemption. I want you to pay the most attention for purposes of this approach to express and implied. So I want you to give a little intro as to express or implied preemption, that there are 2 types of preemption, okay, and then only go into a subheading for the one you potentially have. Now, it's important to note that the fact pattern is not always going to tell you if Congress has acted. We don't have a lot of fact patterns to go off of. We didn't actually, no one even said anything. We didn't actually say when the last time this was tested was. It's in there. What was it? Was it 2008, right? 2004? I know it's February. Hold on. February 2004 was the last time that this was tested. How many bars has taken place since this has occurred? How many bars?
26.
Yeah? Is that right? I have no freaking clue. I'm not good at. Yeah?
25 maybe, yeah.
26 bars have taken place. And the fakakta is a Polish word meaning the freaking bar, state bar, still making us know this. Sucks. Just tell us. And I've badgered them about it. They don't like me very much over there. Now I just don't tell them. I like kind of disguise my voice a little bit. Hi, are you going to still teach the Dormant Commerce Clause? Huh? Miss Carpella, stop calling. There are not a lot of people that work there, by the way. Just a few. I know I get to know all of them there. Okay, so we're still going to know it, right? Because, like you know, the bar is a little tricky. They like to throw in stuff. Okay, so we're going to make a heading preemption. We're going to talk about whether or not we have express or implied preemption. However, and because they don't test it a lot, don't worry so much about it. I feel like who worries about the Dormant Commerce Clause? Right. Don't worry so much about it. It's probably not going to come up. Because every time they test con law, it's usually what? First Amendment, free speech, freedom of religion, equal protection, and that's about it. That's pretty, substantive or procedural due process, which I did predict as well. I think that was that last bar that came up, procedural due process. 2 bars, I predicted that as well. I knew that was coming. I don't know. I'm tooting my own horn. Yes, I am. And no, it's obnoxious, isn't it? Okay, so express or implied. Now, what if you don't have enough facts? What if you don't have enough facts? What if they don't tell you? You still make a heading preemption, and all you're going to say is assuming that Congress has not preempted the field, as there are no facts to determine such, we can proceed to the Dormant Commerce Clause test. And the state can act within this realm. Just hypothetically, something like that. Okay? But we have to address it. We have to consider it. So even if they don't give you facts, just consider it and then get out. Now, if they do, how would you know? Well, there will be a federal statute, page 380. Federal statute explicitly states that the law wholly occupies the field, then the state law will be expressly preempted. So they'll have to give you that in the fact pattern. They'll have to actually give you a federal statute that preempts this area. Now, let's say they do that. Let's say the state is trying to pass a law on, I don't know, where does Congress usually always allowed to act? What is like the number one kind of realm that they have? One arena that usually is for them. Perseverance of what? Anyone know? Natural resources, and they like to test that a lot on the bar. So the natural resources of the country, meaning trees, nature, water, oil, preservation, so basically laws on recycling. Now that definitely could be city-based, but Congress typically has that priority, that they are able to legislate within the realm of preservation of natural resources. And they do test that. A lot of fact patterns about that on the bar, just in terms of Congress's power. So let's say they give you a statute that states the law wholly occupies the field, meaning no other state, no other governmental entity can act in this field. Are you done? Do you say the state can't act here because of preemption? Or do you go on to the Dormant Commerce Clause approach, do you think? What do you think? What would your gut tell you to do? Do you think they give you a 1-hour essay just on preemption? No, you continue to go, okay? You continue to go even if they tell you that the state cannot act there. Now, you definitely want to conclude that even if under the Dormant Commerce Clause test the state can't act, or the state can act, preemption will probably prevent them from being able to. So even within the Dormant Commerce Clause test, if they're able to, preemption will probably prevent them from doing so. Okay, what's implied preemption? If federal law and state law are mutually exclusive, then federal law trumps. Meaning, page 380, if you cannot comply with both at the same time, you have to comply with the federal law. They're going to have to tell you that as well. So usually you'll have an express issue, not an implied issue. And basically all you need to know about the implied is if they tell you, let's say they don't give you the statute, so it's not express, but they tell you that Congress can only act in that area, that's going to trump what the state wants to do. So it's implied. So you don't really need an express preemption if there is a standard going on. Okay, they're going to have to tell you there's an implied preemption of Congress in the country that only Congress can act within this area. I'm seeing a lot of confused faces. Do people, as people not reviewed con law, what does the schedule entail for right now?
Today's our start date.
Today's the start date, so I get it. Okay, so no one's really looked at the law for this yet, right? But generally from law school, right, you have some concept of con law, right? So just try and go with that natural, everyone's like, no, I hated it. Who hated that class? Really? Okay, I actually loved con law. I didn't like the cases. I thought the cases were tedious, so I definitely bought all the canned briefs I could find. But yeah, okay, I get it now. All right, so express, implied, and then where do you go? So then you make a heading, Dormant Commerce Clause. Then you make a heading, Dormant Commerce Clause. So let's go back to the approach. It'll get a little bit more fun. I think this half of the outline is just boring, right? It gets more fun when we talk about freedom of speech and equal protection and that kind of stuff. That's a little bit more action, right? This is like, really, all we hear about on the news and Facebook is like the presidency and all the debates. Why do I have to hear about this now? But it's tested, so we're just going to have to try and like it. Okay, where do I want you to start here? So look at page 404. And see where it says, where Congress has not regulated, see where it says note and then right under it? Where Congress has not regulated a particular subject matter, states are free to regulate interstate commerce on that matter, as long as they do not directly discriminate against out-of-state commerce or unduly burden interstate commerce. Memorize that introduction, please. That is your intro. Okay. So just in terms of setup, you give your intro. And basically, where there has not been preemption, states can regulate as long as there is no, one, direct discrimination, or, it's or by the way, or the regulation is not unduly burdensome. And then you only go into the one that applies. You only go into the one that applies. So the next section of the approach is kind of like an overview. So I actually want you to just put a big bracket around that. So from Dormant Commerce Clause violations all the way till the end of the page, I want you to just put like big parentheses around that. Yeah, exactly what Diksha's doing. Perfect. That exact section. Put a big parenthesis around it, okay? From the Dormant Commerce Clause violations at the middle of page 404 till privileges or immunities clause of 14th Amendment. All the way, that whole section, just put like a bracket around that, okay? That's just an overview of everything. But I actually want you to start next on the top of page 405. So if you have, remember, we're dealing with a regulation that is either passed or going to be passed by the state, by, let's say, California. By the state, not by whom else? Not by Congress, not by the executive branch, but by the state. You go into, again, always standing, state action, the other justiciability issues, mootness, ripeness, maybe third-party standing. You could have organizational standing, right, that three-part test, separate IRACs for each, preemption, implied or express, and then go into the intro over here, okay, and talk about whether or not you have direct. You either will have direct discrimination or it will be unduly burdensome. So what does that mean? Let's first talk about discrimination. How does a state ordinance violate the Dormant Commerce Clause through direct discrimination? What kind of facts are we looking for? On its face, who, yes, it's discriminating, someone knows their stuff, it's discriminating against out-of-state citizens.
Out-of-staters can't take the bar in California or something.
Perfect. Out-of-staters can't take the bar in California. So from, that would be, woo, that would be harsh. But let's just say there was, let's use that example. Good example. Let's say that California passed a law that said that we have too many lawyers here. I actually maybe could see them. They're talking about becoming like their own sovereign, right? I could see them saying, no more lawyers from anywhere else coming here. I really could. But let's just say that happened. So let's say that happened. And we got someone from Nevada. Anyone here from out of state? Okay. Alaska, wanting to come here and take the bar, and they say no. Direct discrimination? Yes or no? Well, let's go through the test. So you make a heading. Remember, we're only going into the one that applies, right? And what is the test? But now we know the facts, right? If a law is facially discriminatory, page 405, against out-of-staters, commerce is presumed to be invalid and violates the Dormant Commerce Clause unless, one, there is an important non-economic interest. So it will be a direct violation unless there is an important non-economic. So in our example, and let me just, before I actually go there, do you think this is going to be a big analysis? Do you think you're going to be looking at both sides of the coin here? Yes or no? Do you think you're going to be, is this like a scrutiny level? Yes or no? Does this look like a scrutiny level? We're looking at these similar types of concepts throughout constitutional law. What did I say at the beginning of class? Con law is all about analysis, right? Both sides, always, always. You have to look at, whenever you have an issue where you're looking at an important interest of a government entity, you have to look at both sides. There's always going to be a counter argument. So creative, good, I would say 3 to 4 sentences on each side here. 3 to 4 good sentences on each side. So back to our example. Does not allowing out-of-state attorneys or law students take the exam in California serve California an important non-economic interest? What's non-economic? Not about what? Moolah, money. Does it serve any important non-economic interest? What would be the argument there?
Like you said,
Too many lawyers, loss of jobs, but that's economic, right? So you see, right away, we're seeing two sides. My point is, look at both sides, reconcile to the stronger argument. Heavy analysis here.
Should we separate the different side arguments into 2 different paragraphs?
You know, counters can either be, it can be in a paragraph as long as you give transition words. So you don't have to separate counters into separate paragraphs. I like to do it that way because I think it makes it look really clear, like here's my strong argument, here's my counter with separate paragraph, and then here's my conclusion reconciling where we're going to, like, my stance is. So I would prefer to do it that way, but if you're on the bar and you're like crunched for time, I would just make a transition word to signal the other side is coming now, okay? And then we have no less discriminatory alternatives. No less discriminatory. So if you look at the standard, there are no less discriminatory alternatives available. What does that mean? Before we look at the exceptions, what does that mean? We're overpopulated. There's no other way that we can preserve our population in California. There's no other way to do this. There's no other way to make sure that we don't have too many lawyers here. And of course, the other side's going to come about and say what? Make the bar harder. Well, let's not. So I love that you're laughing. Con law can get emotional. Let's just be unemotional. I know you're not writing right now, but sometimes in the writing, wow, some people really get into it. I actually had someone a couple of hours ago that came to me with Blue Books and was like, "You're not going to like that essay." I was like, "Why not?" He's like, "That was like, what I really believed in," and I had someone that was killed, and I guess it was a gun control issue, and she really went to town on it, which I can understand. It can be really emotional and political, but let's not do that. The tone is important here. But my point is what? What do you think my point is with this issue? Always argue two sides. So you're going to see me say this consistently. Let's just put it this way. With con law, within your issues, 99% of the time, you're going to be looking at both sides of the coin, especially in this area. So both sides of the coin, you have to be creative. I think that's the hard part. A lot of people like to in all the other subjects, you're dealing with just the facts. And in con law, it's okay to go out. Like, you have to go out a little bit. You have to make up hypothetical scenarios. What else could the state do? The facts are not going to give you that. You've got to be creative there. So if you were a politician, right? Who wants to go into politics? Anybody? Thank God. It just is so dirty right now. I don't know why anyone maybe it's always been dirty. But what would you argue? You have to picture yourself as that congressperson or just or citizen, just saying, what else could the state do, right? And if you watch any news station, that's what they're doing back and forth. That's what they're analyzing. Okay, any questions on just the direct discrimination elements? Yes?
For market participant, under no less discriminatory alternatives, the state can prefer their own, right? Like the Alaska timber case, they can do their own.
Yeah, but we're not there yet. But yes, the state can definitely prefer their own in terms of, but it's also within limit. It's also, there's also limits to it. Okay, so for purposes of approach, we have the two elements for direct discrimination. Everyone understands that, right? We're only going to go into the one that applies. Now, if you have direct discrimination, and only if you have direct discrimination, you may also, right now, have a privileges and immunities clause issue. So remember something. If the call of the question is asking you, does the state's action, this is very important, the call of the question is asking you, does the state's action violate the Dormant Commerce Clause? You're only going to go into one of these two tests. You're only going to talk about the Dormant Commerce Clause, because that's a what? What type of question is that? Specific, right. If, however, the question asks you, did the state's I'm just hypothetically, did the state's regulation violate the Constitution? Then you're going to go into Dormant Commerce Clause, one of these two tests, okay? And if you have direct discrimination, you're also going to consider the Privileges and Immunities Clause right under it. Now, excuse me, because as Mike brought up, we do have two exceptions here. So, wait, let me actually do it over there so it's not confusing. Okay. So let me bring this down. If you have direct discrimination, I want you to always consider, because this goes with the Dormant Commerce Clause, the market participant exception, or congressional approval. this is typically the one that will hit. They'll have to give you facts as to the congressional approval, which they likely will not. A state and local government may prefer their own citizens in receiving benefits from government programs or in dealings with government-owned business. And there's a note there on a little bit more elaboration as what a market participant fact pattern would look like. Okay, so this typically will be your major exception. Do not miss it. Always discuss it. And then you'll go into the privileges and immunities clause. And what is that? When will that clause be violated? When the regulation does what? Interferes with one's ability to earn a living, make money. In my example, who do you think is going to win? The out-of-state lawyers or the government? Out-of-state lawyers, for sure. Right? But don't be conclusory there. Make the argument. They can't come here. They can't pass the bar here. They can't work here. They can't live off, the same interests as others. Okay, so that is and if you go to the bottom, page 405, you'll see that's right under direct discrimination, the privileges and immunities clause. So we're only bringing that up under which form of the Dormant Commerce Clause? We're only going to bring up the privileges and immunities clause if we have what? Direct discrimination. Good. Now go to middle of page 406. If the state or local law does not discriminate. Everyone have this? Yes? Okay, good. So what happens if the local or state law does not discriminate? What is your test there? So just to kind of bring it home, let's erase all this. Con law is such a big subject, but I hope by the end of tonight I'll have condensed it enough so that you know just what you need to really know. All right? That is my purpose of this evening. Okay? And so far we have maybe 1, 2, 3, 4 categories that we really need to know so far. Okay? Let's say you're going into unduly burdensome. Only discuss that which applies. Page 406. If the law burdens interstate commerce, it violates the DCC. If its burdens exceeds its benefits. We have a burden-benefit test. The burden on commerce outweighs the local interests protected or benefited by the legislation. However, even if the law, and this is literally just your intro to all of it, you can condense this, okay? Even if the law unduly burdens interstate commerce, it may still be valid if the state is acting to further an important interest and there are no less discriminatory alternatives. This standard can be confusing because what do you mean there are no less discriminatory alternatives? I thought it's not discrimination. This is the law. So we're going to do our best with it. All right, so we have a balancing test. This is the most important part of the unduly burdensome. What are we balancing? So give a little intro as to the balancing test. You can condense that standard. The most important thing is that you state that the burden exceeds the benefit and that the burden on commerce outweighs the local interest protected by the legislation. That is the burden balancing test. And then you're going to actually balance it. What are you balancing? Page 406 bottom. Weigh the burden on commerce versus the important state or local interest. So this regulation applies to everybody, not just out-of-staters. That's how you know that you're going into this test. It applies to all. Citizens of the state and non-citizens. It applies to all. The burden on commerce versus the important state or local interest. Okay? This, what do you think? Will this be a pretty lengthy analysis here on this balancing test, looking at both sides? So I would do a burden analysis, I would do a benefit analysis, and then I would say who's going to win. Again, we're looking at the burden on commerce and whether or not it outweighs the local interest protected or benefited by the legislation. Who has the course schedule? I want to see something. Oh, I have it. Thank you, I have it. I want to see one thing.
So should we
So,
put different heading for burden and benefit?
You can. You don't. I mean, it's not required as long as it's the burden and the benefit. If you, I mean, if you want to, I have seen it both ways. So, let's just say as a rule of thumb, yes, let's do it that way. Let's really make it a full-blown balancing test. Okay. I have assigned this essay for issue spotting. This exact one that you're going to be. The only one that we saw in the last 26 bars. So it has been assigned. Okay, good. Put this here. Okay, excuse me. So to finish the test, where do we go from here after we do that? We have to look at well, how do we do that if it's not discriminatory? Does anybody have an idea? What do you think? What do you think? Doesn't really make sense, right? Does everyone understand, get that, right? It doesn't make sense. We're saying it's a non-discriminatory regulation, but then one of the elements to the undue burdensome test is that there's no less discriminatory options. Okay? So in this test, I don't want you to think of the discrimination in terms of out-of-staters. Okay? I want you to think of it in terms of the unfairness to everybody. So is there another way that could make it fairer for everyone that could be impacted by this ordinance so that they don't have to be as impacted by it? So here the discrimination the direct discrimination we were looking at was regarding out-of-staters, okay? Here it's regarding everybody. So think of it more as unfair or unequal. Well, actually no, not unequal, unfair. Is there another way that the state can protect? Let's say the state passed a law that said both in-state garbage truck companies and out-of-state garbage truck companies, right? So California and let's say Nevada or anyone else cannot drop more than, how much garbage do you think a garbage truck drops in like one shot? A ton? Half a ton? Okay, so let's just say cannot dispose of more than half a ton of garbage at one given week. That affects everybody, right? But those garbage companies could lose out on their productivity of their business. So your job is to say, is there any way else that the state can go about it? So this is where your mind really has to go outside. You can kind of BS a little, but let's talk about that for literally a minute. What's another way that the state, in my example, could act? What could they do? What if they reached out to other states and said, well, you know, your trucks are, you know, and my truck, we have a lot of garbage going on here. Let's kind of work together. That could be one, right? One possible solution. Or maybe they could open up more land for garbage disposal, right? So some of your arguments may kind of seem like you're pulling them out of the air. Pull them out of the air. I have seen some of the highest scored con law essays, and they were so BS'd and full of hodgepodge, I just couldn't even believe it. And if Seriously. So just, I don't want you to BS, but this is an area that you really have to pull a little bit more than the facts, okay? All right. We're also going to consider here the market participant exception as well. That is the only exception that applies here. Now on page 407, I have given you a chart to kind of like an overview of this, so definitely study this for more clarity within this area. I don't want to spend any more time here because it really has not come up. Oh, what's wrong with me tonight? I'm so clumsy. And I don't know if it's going to come up, but hopefully this gives you really just a very tangible elemental test to work with so that you know where to go. So just to kind of, let's all look up, okay? Let's kind of like just reiterate this approach. Let's actually go back to the beginning. Let's go back to the beginning. I'm going to test your memory power here. Okay, so the first thing you're going to consider on a con, everyone look up. What's the first thing you're going to consider on a con law essay? Then what? Okay, what's a big floater that could come up there? Good. Ripeness, mootness, and I'm looking for one under third party. Organizational standing that has a what part test? Three-part test. What's another floater concept that comes in when you have a private individual trying to sue the state? Or a government entity? Sovereign immunity. Are there exceptions to sovereign immunity? Yeah, when that can happen, right? Know them. Okay, what's the next category in con law that comes up? Just going in order. What's the next category that we had on the board? I'm not saying it. We're going to sit here all night. What? There you go. Powers. This is what I mean by checklist, by the way. When I say checklist when you go home, this is what I'm talking about. The universe of where they could go. Okay? So we have, it's okay. Next we go to powers. Just think of powers. And there's three potential powers. The Supreme Court powers, executive powers, both domestic and foreign. And then the third power is what? Legislative, right? Think of it like the three branches of government. Think of it like that. You have Supreme Court is kind of like off on its own, but you have possibly the president acting in a fact pattern. You have possibly Congress acting in a fact pattern. And then if you have the Dormant Commerce Clause, you have the state acting. Okay? Try and think of it like that. When you have the state acting, what's your first consideration other than these issues, just the justiciability issues? Let's say you've passed that. Where do you go next? Preemption. And how many types are there?
Express and implied.
Great. Express or implied. You're typically going to have which one?
Express.
Or neither, right? Then where do you go?
Dormant Commerce Clause.
Dormant Commerce Clause. Great. And after that, you hit whether or not you have what?
Direct discrimination.
Direct discrimination, or what's the other test? Undue burden. The undue burden test. Under direct discrimination, this is going to be hard because I know this is pure memorization. But under direct discrimination, what do you have to prove? It's okay. Take a moment.
The state discriminates against out-of-states.
The state discriminates. Okay, that's the general concept. But what's the test? What's the actual test? Yes. Yes, non-economic state interest. Perfect. And then the second part of the test? Second part of the test. No less it's okay. What I'm doing now is I'm trying to make you understand what I mean by going home. This is what you should doing over and over until you get it. No less discriminatory alternatives, right? Then where do you go from there? Where do you go from there? Exceptions, market participant, or congressional approval. Okay, everyone take a deep breath. You got this. Then where do you go? If it's discriminatory, what else do you consider in a general question? Beautiful. And what is that very simple standard? Privileges and immunities? It's what? When? Yes. Everyone gets that, right? Because no one wants anyone fucking with their ability to make moolah, right? Especially in this city where it's so expensive. This pen was like more expensive than anything. No, I'm just saying like California is just ridiculous, especially LA. Okay, not losing my train of thought. Then let's say we don't have discrimination. What's the other test then? Unduly burdensome. Unduly burdensome test. The first thing that we're going to do, what's our Our bread and butter there, our points are going to come up with this what? This balancing test, right? We're going to balance the burden and the benefit on commerce. And we're going to then discuss, again, the same issue, no less discriminatory alternative, but here it's regarding everybody, not just out-of-staters. Is there an exception we're going to consider for undue burden?
The market again.
Fantastic. Okay,